Hello. In today's presentation, we shall be looking at defenses to negligence, and we shall examine first the defense of contributory negligence. The defense of contributory negligence as one of the principal defenses to the tort of negligence. As we go along with the presentation, I would enjoy you to subscribe to this channel, like, and share this presentation. What do we mean by contributory negligence? From the title, it means that there is a form of contribution to the negligence, but by who? By who? And what are the key elements of this defense in the tort of negligence? In order to do our presentation, once again, I'll be sharing my screen as usual. And so the defense of contributory negligence as developed at common law was a complete defense initially. It was a complete defense. And by that, it meant that once you are able to establish that a claimant in a tort action is contributory negligence, there will be no liability in the defendant. But we will see in this presentation how that defense has developed. So what do we mean by contributory negligence? Lord Dennis stated in the case of Jones and Linus Perez that a plaintiff or a claimant would be guilty of contributory negligence if he ought reasonably to have foreseen that if he does not act like a reasonable prudent man, he might hurt himself, and that in his reckonings, he must take into account the possibility of others being careless. In other words, as we go through our daily activities in life, we must self-protect ourselves. We must watch out for our own safety, like a reasonable and prudent man. While you are not expected to be looking over your shoulders all the time, you are expected to take some reasonable precautions to protect yourself for your own safety. So you must foresee the possibility of damage to yourself in certain situations and contexts. And in this regard, like I said earlier, that if you are able to establish that a defendant's action, a plaintiff's actions contributed to the damage that he has suffered, the law was that the claimant or the plaintiff would not be able to recover any damages. But there has been statutory intervention which tries to mitigate the harshness of that rule. In Nigeria, you have what we call the law reform tort laws of a lot of states. And Lagos State, for instance, has a provision that says that if a plaintiff suffers damage as a result partly of his own fault and partly of the fault of another person's, a claim in respect of that will not be defeated by reason of the fact that the person suffering the damage was contributory negligent, so to say. That in other words, it shall not be able to, the defendant shall not be able to escape liability by saying that the plaintiff did not act like a reasonable and prudent man. So that provision is a statutory attempt to mitigate, to reduce the harshness of the common law. Now, the key issue in this defense is that the claimant did not act like a reasonable and a prudent person in terms of his own affairs, and that action contributed to his damages. His conduct contributed to his damages, not that it contributed to the tort, to the breach of duty, but that it contributed to the damages that he suffered. That, in other words, it failed to take reasonable care for his own safety. And some of the examples of cases where this has been held were cases where someone, a pedestrian, for instance, had crossed the road without looking out properly before he crossed. you know, or where someone rode on a motorcycle and he did not, as a passenger, did not wear a crash helmet, and then there is an accident, failure to wear a crash helmet is not necessarily the cause of the accident, or it's not necessarily the cause of the breach of duty by the rider, but that by not wearing a crash helmet and now him hitting the head of the ground contributed to the injury, to the damage that he has suffered. Or where you have passengers not wearing a seat belt, like in Full and Butcher. The fact that somebody did not wear a seat belt is not necessarily the cause of the accident, the event that happened. Maybe the driver ran into another vehicle. So it's not the failure to wear the seat belt that causes the breach of duty, but that the failure to wear the seat belt contributed to the damage that the passenger had suffered. We also have cases where someone rides on the tow bar of a vehicle. In Nigeria, for instance, you have bus conductors riding at the back of their buses, or someone just jumps on the back of a bus to hitch a ride, and then you have an accident happening, and this person is injured. Or when somebody gets into a vehicle or an aeroplane with a person that you know for sure has been drunk, maybe because we were drinking together, or as a fact, you had witnessed the person completely drunk, and then the person crashes the vehicle and the passenger is injured. These are some of the contexts in which contributory negligence had arisen. The whole idea is that the actions of a claimant contributed to the damages that he has suffered. So as a plaintiff, as a claimant, the law requires that you should also watch out for your own interest. And the standard of care that you are expected to exhibit is the same standard of care that is used for negligence. We talked about the objective standard to act like a reasonable and prudent man. So it's an objective test. How would a prudent and reasonable man have acted? Would a prudent man, with a reasonable man, have gotten into a vehicle with someone that you know is worse for drink? Do you have ridden a vehicle without using your seatbelt? These are some of the considerations that are taken into context of each case. Still talking about the reasonable man, when it comes to children, the age of the child becomes a critical consideration, and the courts are not too disposed to hold a child as being contributory negligence. But of course, we take the cases in the context of their own facts. In Yachuk against Oliver Blaze, for instance, the fact that the defendant supplied fuel to a 9-year-old child who had lied that the mother needed it for her car, when in fact the child wanted to play with it and the child was burnt, the court was not disposed to hold that child as being contributory negligent. Rather, the court held that the defendant was negligent in giving fuel to a 9-year-old child who at that age is not expected to appreciate the dangers involved in the handling of fuel. And so they could not raise the defense of contributory negligence against the child. And Londoni had actually stated that the child should not be found guilty of contributory negligence unless he or she is blameworthy. Then you have people under disability that the court might likely consider their cases, the context of their limitations. There are situations where a defendant puts a plaintiff in a situation where the plaintiff has to make some urgent and critical decisions, which invariably causes damages to that plaintiff. And examples would include situations where the defendant, for instance, maybe a vehicle driver driving a vehicle and is about to have an accident, and a plaintiff in the vehicle maybe sees that they're about to have an head-on collision with another vehicle, decides to jump out of the vehicle and gets injured. In this context, the courts have held that where a defendant puts a plaintiff in a dilemma, that's what it's called, a dilemma whereby the plaintiff has to choose between two alternatives, and the plaintiff chooses the one that causes more peril, that is more perilous in the heat of the moment. The defendant cannot argue that the plaintiff is guilty of contributory negligence. He cannot do that. As long as the plaintiff acted like a prudent and reasonable man, in the light of the facts of the case, the courts will not hold him to be guilty of contributory negligence. So essentially, therefore, contributory negligence is a major defense to tort of negligence, and it is a partial defense. What happens is that when this defense is canvassed, the court would apportion liability. It will apportion liability based on the percentage of the plaintiff's contributory negligence. So if the court, for instance, found that in the light of the fact you did not wear a seatbelt as a plaintiff, and that is why your damages, your injury was incurred, the court might hold that failure to wear a seatbelt, for instance, was 40% cause of the damages. And so the damages will be reduced by 40%. It is called apportionment of damages. The court will look at the context and determine which percentage of negligence can be ascribed to the plaintiff or to the defendant, and apportion the damages accordingly. And that's also to be done where you have multiple defendants, So contribution negligence is not a complete defense, it's a partial defense. It does not mean the defendant will escape liability, but rather that the damages will be apportioned between the plaintiff and the defendant. In the next video, we shall be looking at another kind of defense. Thank you.